Friends, today we are dealing with the various types of jurisdictions of Supreme Court. We know that Supreme Court is having different types of jurisdiction like original, appellate, advisory, and inherited plenary. So broadly, we can say four types of jurisdictions are there for Supreme Court. So first one is original. What is this? Original jurisdiction. Second one is appellate jurisdiction. Third one is advisory jurisdiction. Fourth one is inherent and plenary jurisdiction. So come to the first one, original jurisdiction. What is original jurisdiction? Original jurisdiction means which court can approach first. That is called original court. Suppose if at a first instance we can approach the Supreme Court, we can call it as original jurisdiction. So here Constitution provides the original jurisdiction to the Supreme Court. So again this original jurisdiction can broadly be divided into two categories. That is ordinary original jurisdiction and extraordinary original jurisdiction. Here under Article 131 some jurisdiction has been provided to the Supreme Court. It is called original jurisdiction under Article 131. Today we only confine to various types of jurisdictions and its legal provisions, not in depth. So what legal provision controls the original jurisdiction? So Article 131 is the basic provision to control the original jurisdiction, deals with the original jurisdiction of the Supreme Court. Article 131, along with we know that the Supreme Court is having its own rules. Supreme Court rules 2013. Earlier it is 1966. Thereafter it is 2013. So along with that rules also we have to understand. So original Article 131 along with Part 3A of Supreme Court rules, that is Order 25 to 37. Order 25 to Order 37 deals with the original jurisdiction. What is original jurisdiction? If suppose any dispute between central government and one state, or any dispute between central government is one side, two or more states other side, or any dispute between two or more states, this is called original jurisdiction. So Article 131 and Part 3A, that is Order 25 to 37 deals with the original jurisdiction. Okay. Again, what is extraordinary jurisdiction? Extraordinary original jurisdiction. Under Article 32, we know that any person aggrieved by any violation of fundamental rights directly can approach a Supreme Court. That is called Article 32. Because of it is enabling provision to approach the Supreme Court at first instance, we call it as original jurisdiction. Because of it is an extraordinary in nature, we are calling it as a extraordinary original jurisdiction. Article 32 along with the Part 3B of Supreme Court Rules 2013, Order 38. Order 38 deals with this extraordinary jurisdiction. We are not going in detail further details, because we are today in this video we are confining only to what are the basic legal provisions that deals with the various types of Supreme Court. That's all. Okay. In the same category, in the same original jurisdiction category, another 2-3 types of jurisdictions are there. That is transfer jurisdiction. What is transfer jurisdiction? We can directly approach the Supreme Court regarding transfer of some matters. If you take the Article 139A, is having two subclasses. 139A1 deals with one type of transfer petition. Which type of transfer petition? Suppose some matters are pending in one high court, or suppose matters are pending in two different high courts. Then the similar matter is pending in Supreme Court. The Supreme Court can call all the records, all the files from the high courts or one high court or different high courts to the Supreme Court to decide the matter. If there is a substantial question of general importance, any question involved in substantial nature and its general importance, then Supreme Court on its own or an application made by somebody, it can call, it can withdraw all the cases from the concerned high courts and decide by its own, by Supreme Court itself. That is 139A1. That order, Supreme Court rules order also is there, that is 40. Order 40 and 139A1 deals with such type of transfer cases. The another one is 139A clause 2. 139A clause 2, normally all individual transfer cases, one high court to another high court. Suppose matters pending in one high court and they want to transfer that matters to another high court, then this provision will enable such a situation to dealing with such a situation by Supreme Court. So 139A clause 2 and order 41. Here 40, this is 41. Next, section 25 CPC. We know that under section 25 CPC, we can file transfer petitions from one high court to another high court. That is 25 CPC along with order 41. Here also 41, this also 41. In the same way, section 406 of CRPC. This is also criminal side. 406 CRPC, criminal side's matter can be transferred one high court to another high court and different perspective. That is called 39. So all transfer petitions which can be dealt with section 406 or CRPC along with the 39 of order 39. This is. Next, another one is election petition. There is one act, we know that President and Vice President Elections Act 1952. Under this act, any election is in dispute, any election of the President and Vice President dispute is there, then we have to approach at first instance directly to the Supreme Court under this provisions, Article 71 and Order 46. So this is one jurisdiction. Because it is original in nature, we are calling, and it has been located in original category. The another one is arbitration. Arbitration and Conciliation Act. There is a scheme called Appointment of Arbitrators by Chief Justice of India scheme. Under that scheme, under this Arbitration and Conciliation Act, section 11(5), that with this scheme, Chief Justice of India can appoint arbitrators in arbitration disputes. It is also original jurisdiction. It comes from 1996 onwards. So, it is called original jurisdiction. Okay. So, this is regarding original jurisdiction of the Supreme Court. Then come to appellate jurisdiction. In this appellate jurisdiction, several types of appeals are there. Appellate jurisdictions are there because of statutes and constitution and other things. Appellate jurisdiction is there to the Supreme Court. If you take this article 132, 133, 134 and along with 135, 134A read with order 19 and 20. So 132, 133, 134, 134A read with order 19 and 20 deals this type of appellate jurisdiction. What is the purport of these articles? You know, any judgment, decree or order passed by any high court which if you take Article 132, there is a one phrase. Suppose if any question, any substantial question of law as to the interpretation of constitution. You see here question of law, different types of question of laws. 132 deals with the one type of question of law. 133 deals with one type of question of law. So we have to carefully observe which type of question of law has to be involved to come under that provision. You take 132, what provision says? There must be involvement of substantial question of law as to the interpretation of constitution. If that question of law is there, if any judgment, decree or order passed by any high court, appeal is provided under this article to the Supreme Court. That is one. If you take 133, 133 deals with 132 deals with civil, criminal or any other proceedings. So it is neutral, for all types of, there is no classification. But 133 deals with only civil matters. That too, a question should be involved regarding substantial question of law of general importance. Substantial question of law of general importance. Here it is not interpretation of the constitution. 132 interpretation of the constitution. 133 civil and substantial question of law in general importance must be there. If any such type of question involves, then 133 comes. Next 134. 134 it deals with the criminal, particularly criminal matters. If any acquittal order has been challenged to the High Court, and High Court in its judgment reversed the acquittal and sentenced him to death, such judgment can be challenged under 134 clause 1. In the same way, if any case pending before the subordinates to the High Court is withdrawn on its own and the death sentence is imposed, in such circumstances also 134 comes to rescue. That means under 134 we can file appeal. Regarding 132, 133, who decide to say that there is a substantial question of general importance or there is a question of law regarding interpretation of the constitution? All this has to be certified by High Court under Article 134A. So that is condition for all three, 132, 133, 134. When comes into picture, if High Court gives such certificate, then the appeal lies to the Supreme Court. So these are the three different types of appeals. So Order 19 and 20 in Supreme Court rules. Okay. Thereafter, statute appeals are law, any appeal provided by law. What is statute appeals? If any statute, take Consumer Protection Act or any other acts, if appeal directly lies to Supreme Court from the basic court, it is called statute appeals or law appeals. The section orders in 2013 rules 19 and 24. Here 19 and 20, here 19 and 24. Next, section 2 of Act 1970, that means enlargement of criminal jurisdiction of Supreme Court Act 1970 is there. So some appeals come under this act. So appeals under this act can be dealt with along with the Order 20 of Rules 2013. Then Article 136. This is extraordinary appellate jurisdiction. Why it is extraordinary appellate jurisdiction? Because granting of leave is involved in this case. So on any matter, it is either civil or criminal or any matter from different high courts or tribunals, if with leave petition can be filed in Supreme Court. So it is extraordinary. We come to 136 separate. But what is the condition is that is also question of law. Next, here two types of appeals under 136. That means what? Suppose once leave granted under Article 136, it become an appeal. So what is the fourth type of category here? If any appeal, any leave granted under 136, upon granting of such leave, it can be called as appeal. So that is one type of appeal. And even if it is petition filed under 136 also can be called as appeal. So these are the different types of appeals. This is about appellate jurisdiction of Supreme Court, particularly legal provisions only. 136, Order 21 and 22. So enabling provisions only we are dealing now. This is appellate jurisdiction. Next, come to advisory jurisdiction. In advisory jurisdiction, references are there. There are several types of references. 7 types of references are there. So we know that very popularly, that is President can refer the matter any seeking advice under Article 143 Clause 1. 143 Clause 1. Which type of advice he can seek? When any question of law or fact of public importance. Question of law or fact of public importance involving such question can be referred by the President under Article 143 Clause 1. The order is 42. The rules, dealing with the rules, Order 42. Next, 143 Clause 2 has having another type of reference. That is 131. Article 131 proviso is having some questions. So under Article 131 proviso also President can refer under Article 143.2. Under Article 143.2, reference can be sent to the Supreme Court dealing the subject incorporated in proviso to Article 31. So what is Article 131 proviso? We will discuss later. So the enabling legal provision is in Supreme Court rules Order 42. Next, reference under Article 371. What is 371? Regarding removal of Public Service Commission chairmen and its members on misconduct ground. So misbehavior ground. So 317C, Order 43. Next, reference. Here, reference can be done by President, reference can be done by Governor, reference can be done by Central Government, reference can be done by tribunals, and reference can be done by Income Tax Appellate Tribunal. So, we deal with all these things. Now, up to Section 14 Clause 1, Right to Information Act, this can be done by President under Section 14 Clause 1 of Right to Information Act 2005. This enabling provision in Supreme Court rules is Order 42. In the same RTI Act, Governor can refer Section 17 Clause 1. This enabling provision in the Supreme Court rules is 42, same. Then 54 of rules deals with the reference of central government or tribunals. Any reference can be done by Central government or tribunals. Next, section 257 of Income Tax Act 1861. Under this section 257 of Income Tax Act 1861, Income Tax Appellate Tribunal can, President of Income Tax Appellate Tribunal can refer any matter to the Supreme Court under this section. The order deals with this particular subject is 45. So, Income Tax Act appeal reference is order 45, section 257. So, these are the broadly various types of references, that means advisory jurisdiction of the Supreme Court. Next, inherent and the plenary jurisdiction. What is inherent? Inbuilt. Inbuilt. If by originally if there is any inherently jurisdiction, it is called inherent jurisdiction. If you see, Supreme Court is having plenary. Plenary means what? Unqualified, absolute. It can pass any orders. It can decide any case. So, to do complete justice or to prevent miscarriage of justice or to Supreme Court is having plenary and inherent. Suppose any error caused in delivering judgment, order or decree, it can be cured by reviewing its own judgment, that is under Article 137. So, Article 137 is the reviewing provision of the Supreme Court. The particular order is 47. Rule order 47 of Supreme Court rules deals with the Article 137 of review of Supreme Court. Next, contempt. Section 3, 1975 of contempt rules and Article 129 and 142. Under these articles also, so a Supreme Court is having inherent. It can enforce its own order by invoking these contempt rules. And also, the expansion of review, further review. Further review to prevent miscarriage of justice. This curative procedure has been developed by Supreme Court in Ashok Hurra, Ropa Ashok Hurra versus Ashok Hurra case. Ashok Hurra case. So, it is because of law made by the Supreme Court, judgment made law, in Supreme Court rules, it is incorporated under 48, order 48, it is there. And another thing is Supreme Court Enforcement of Decrees Act 1954. Any decree passed by Supreme Court can be enforced through this Act section 2. So through this section also, it is having its plenary and inherent jurisdiction. So these are the broadly various types of jurisdictions and legal provisions enabling such jurisdiction. That's all.